Welcome to our deep dive on the green card dilemma, choosing between continuing a U.S. immigration process and preserving a stable, thriving life abroad. In this video, we will explore when pausing or even abandoning a U.S. green card pathway may actually serve your family better. First, let's preview what we'll cover. Here's the agenda for today. First, we will define the dilemma many binational families face. Next, we will explain how your current procedural status changes your options. Then, we will detail specific tools for lawful permanent residence like Form I-407 and reentry permits. Afterward, we will evaluate the cost of delaying life. Then, we will walk through a decision flow. Next, we will compare staying put versus pushing the immigration process. After that, we will test your understanding with short quizzes. And finally, we will summarize key points. Before diving in, let's set an important disclaimer. Before we move forward, please note this video is informational and not legal advice. Immigration law is complex, fact-specific, and changes over time. Consult a licensed immigration attorney for personalized guidance. With that in mind, let's define the dilemma clearly. Here is the core dilemma. Families thriving abroad weigh whether to disrupt a stable situation for the sake of advancing a U.S. immigration case. Strong careers, embedded community ties, secure housing, and children's routines create real value. Sometimes, prioritizing that stability over immigration status is the better decision. Now, to act wisely, you must understand your exact procedural status. If your case is at the I-130 or National Visa Center phase and no immigrant visa or green card has been issued, you can choose not to proceed. The case will eventually lapse. If you decide to relocate years later, you can file a new I-130 and pay the necessary fees, essentially restarting the timeline. The downside is mild, because you never became a permanent resident, and therefore you are not abandoning permanent residence. Next, let's discuss the situation for those who already hold a green card. This flowchart illustrates the decision path. First, identify your status. If you are at a pending or approved I-130 without a visa, you can pause and allow the case to lapse, accepting that you will need to restart later if you choose to move. If you already hold lawful permanent resident status but do not intend to maintain U.S. residence, the cleanest step is filing Form I-407 to formally abandon, which removes confusion during future visits. If you expect a temporary but extended absence while retaining LPR status, consider a re-entry permit using Form I-131. But remember, it requires you to be physically present in the United States to file and complete biometrics. Conclude by weighing stability and only proceeding when relocation is genuinely desired. Next, we unpack LPR-specific options in more detail. For those who already hold permanent residence, the rules presume actual residence in the United States. Extended time abroad can be viewed as abandonment. Absences exceeding 6 months may trigger scrutiny. And absences of a year or more typically create a presumption of abandonment if you lack a re-entry permit. If you no longer plan to live in the United States, filing Form I-407 provides a clean, formal end to permanent residence and helps avoid complications when entering as a visitor later. If life changes, you can always seek a new immigrant petition in the future. Now, what if your absence is significant but temporary? Let's look at re-entry permits. A re-entry permit allows a permanent resident to remain outside the United States for an extended period, generally up to 2 years, without triggering a presumption of abandonment. However, the critical requirement is physical presence in the United States to file the application and complete biometrics. This often disrupts an otherwise settled life abroad and may not align with family priorities. It is best suited for predictable, temporary absences, where long-term residences in the United States is still intended. Next, let's directly compare the benefits of staying abroad versus pushing forward with immigration. On the left, staying abroad preserves career seniority, community ties, and children's schooling, and avoids disruptive and expensive travel. It also keeps options open to restart later. On the right, pushing forward accelerates relocation and may secure immigration status sooner. But it often creates immediate disruption to careers and schooling, and may result in opportunity costs if the family later chooses not to remain in the United States. Up next, we quantify what is lost or preserved when pausing now. This table contrasts key aspects. If you pause at the I-130 stage or let it lapse, you will pay new petition fees later and restart the timeline if you choose to immigrate. If you abandon permanent residence with Form I-407, you will similarly need a new case and fees later. In both scenarios, career seniority and family stability remain intact, and future travel to the United States can continue under regular visitor rules applicable to your nationality. Now, let us visualize the entire decision process with another perspective. Consider the compounding effects of delay. Career progression often depends on seniority, licensing milestones, and continuity. Family planning is sensitive to timing and support networks. Indefinite uncertainty imposes a mental burden. While immigration petitions can be restarted, lost time and momentum are hard to reclaim. Therefore, avoid putting life on hold for a hypothetical schedule. Next, let's test your understanding with a short quiz. Quiz time. Question: if your I-130 is approved but no immigrant visa or green card has been issued, what happens if you simply stop at the National Visa Center stage? Options. A. You will be banned from refiling for 10 years. B. The case will lapse, and you can refile later and restart the timeline. C. You keep your spot in line indefinitely. D. You must file Form I-407 immediately. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. If no immigrant visa or green card has been issued, the case can lapse, and you retain the ability to refile later, restarting the process and paying new fees. Now, let's try a second question focused on permanent residence. Second quiz question. If a lawful permanent resident does not plan to reside in the United States and wants a clean path for future visits, what is the safest formal step? Options. A. Do nothing. B. File Form I-407 to abandon permanent resident status. C. Apply for a tourist visa while keeping LPR. D. Remain outside the United States for exactly 364 days each year. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Filing Form I-407 formally ends permanent resident status, which helps avoid confusion about immigrant intent during future entries as a visitor. Next, let's provide a concise Markdown recap you can screenshot and save. Here is a quick Markdown recap. First, consider pausing if your family is thriving abroad with strong careers, community ties, and young children. Second, if you are at the I-130 or NVC stage, you can allow the case to lapse and refile later if relocation becomes a real goal. Third, if you already hold permanent residence and do not plan to reside in the United States, file Form I-407 to end the status cleanly. If you plan a temporary long absence while retaining residence, consider a re-entry permit, understanding the need for physical presence in the United States to file. Finally, follow the golden rule: do not put your life on hold for a hypothetical timeline. Now, let's consolidate key takeaways. These are the key takeaways. First, identify your status. Second, at the I-130 or NVC stage, pausing is simple and you can refile later. Third, as an LPR, you should either maintain genuine residence, use a re-entry permit for temporary long absences, or file I-407 if you will not reside in the United States. Fourth, value time and stability, because immigration can be restarted, but lost momentum is hard to regain. Finally, consult a qualified immigration attorney before making irreversible decisions. To wrap up, let's summarize and point to next steps. In summary, when your family is thriving abroad, prioritize lived stability over paperwork. Your current stage in the process determines your most prudent option. Let the I-130 lapse. File I-407 to end permanent residence if you will not live in the United States, or use a re-entry permit for defined temporary absences while accepting the practical hurdles. Keep options open, reduce disruption, and consult counsel for tailored advice. Finally, here is our closing message. Thank you for watching. If this video helped you, please like, share, and subscribe. In the comments, tell us what you would choose and why. Your experience can help others facing the same decision.